Good morning, everyone, and welcome to the Utah Court of Appeals. We are here this morning for two matters, and the first one is case 2022-1019, State v. Wall. I am Judge Oliver, and I'm joined here on my right by Judge Christensen Forster, and on my left by Judge Luthi. We are doing a hybrid version of argument this morning, so it looks like I have on my screen Ms. Levitt-Howell. Is that you?
That's me. Yes, Your Honor.
Okay, and I can hear you and see you just fine. And counsel here in the courtroom, if you'll make your appearance for us.
William Haynes for the state of Utah.
All right, Mr. Haynes, good morning and welcome. I will just point out, since we're in a hybrid fashion, that the computer screens with the image for the judges are to our right. And so when the appellant is presenting her argument, it will look as if we are looking to our right, because we are, so we can see the computer screen. And then when we hear from appellant in the courtroom, we'll be back looking forward. But if anyone is watching on our YouTube channel or doing a later replay, just for their benefit, that is why you will see the sides of our face for parts of this argument. It looks like I have 12 minutes on the clock, so Ms. Levitt-Howell, have you reserved 3 minutes for rebuttal then?
That's correct, Your Honor. Thank you.
Okay. Do we have any questions from either counsel before we begin?
No, Your Honor.
All right, then Ms. Levitt-Howell, please begin.
Thank you, Your Honor. Mr. Wall presents 4 issues to this court. First, the trial court improperly restricted voir dire. Second, he presents a preserved claim of prosecutorial misconduct. Third is an unpreserved claim of prosecutorial misconduct. And fourth is a hearsay claim. So looking at the voir dire issue, it's instructive to compare and contrast this case with Williams, Lillay, and Holm. And this court is not like Williams. In Williams, we saw long, lengthy rhetorical questions from the prosecutor, embarrassing jurors. She embarrassed jurors by asking them to describe their last sexual encounter, praised jurors for answers that she liked, and told them who they could believe, while also making general pattern or broad proclamations about the patterns of sexual abuse. And ultimately, this court explained in Williams that that didn't look at any sort of bias. In fact, it wasn't really questions, it was just statements that were meant and designed to expose the veneer to the prosecution's theory of the case. And so where it didn't look into any sort of bias and instead only sought to convince the jurors of the state's position before they even really got started, it was improper. And it's a similar issue in Lillay, where I think it's useful to read those 3 questions in particular that were at issue in Lillay. The first was, if Mr. Lillay were to testify, would you give his testimony the same weight and credit that you would give any other witness? And the court pointed out in that case that it maybe was a correct inquiry to question whether jurors could give someone who had been arrested or a criminal defendant the same credit that they would give other witnesses. But the issue with this question in particular was that it wasn't just criminal defendants broadly, it was Mr. Lillay in particular. And he could be pointed to on the stand. And the question at issue here, I apologize, I should have clarified earlier, was, do you believe that children are capable of lying about significant events? And so that question is very different from this question because it doesn't point to a particular witness. It doesn't ask the jury to weigh one person's credibility against all other general people. The second question at issue in Lillay is, if after hearing the evidence you came...
Ms. Levitt-Howell,
Yes.
before you go on to that second question in Lillay, I actually think that the first question in Lillay is potentially quite similar to the question here, in that the court acknowledged and said, we agree with the defendant, the objective of question 26 was proper. A judge should allow questions purporting to discover possible biases against a defendant as a witness. The court recognized that question goes to bias. Bias is a proper subject. But then the court immediately said the form of the question, however, is problematic. And it seems like that may be the case that we have here, where, yes, the bias as against the credibility or non-credibility of child witnesses, I think does raise a question of bias, but that perhaps the form of the question was what was concerning to the trial court. And in your brief, you recognized that the trial court appeared to be concerned. For some reason, I feel out of breath. I'm going to take a deep breath. That the question also highlighted the defense's theory of the case, that our key child witness is lying. Is that not, at least to that point, on all fours with that question in Lillier, that yes, it goes toward bias, which is proper, but the court also may look at the form of the question and say we need to address that bias in a different way?
So 2 points, Your Honor. I mean, I think it would be a fair response for the court to say we should look at the form of the question. But Mr. Wall's question is different from the one in Lillet because, first of all, it is about children generally. And that's an important distinction. Where the question in Mr. Lillet's case was about Mr. Lillet specifically, this is about children generally. So, I mean, that's one distinction. And the second distinction is also, I mean, I think we should look to Holm, maybe. And in Holm, the court didn't actually have a specific question that the jury, or excuse me, that the defense wanted to ask. The defense just said, I should be allowed to ask questions of these people who said that their family members were in a serious car accident. And even without the specific question, it was the barring of that entire subject, or just barring any further inquiry, or any sort of question, was improper there. And then third, I think the record would suggest that the court wasn't just upset about the form of this question, but just the subject matter broadly, because the other questions, in fact, the question right before that defense counsel addressed with the court, I believe the court said, well, maybe we can tweak this a little bit, but I'm not going, and right, the court engaged in a discussion with defense counsel about how other questions could change so that they could be asked and were proper. But this question, there was no discussion. It was just a blanket statement. I will not allow that question, and that was what was improper. So I guess I would disagree with the statement that the court was upset with only the form of this question, and it moved into the subject matter.
If the court had, of its own initiative, said, I don't think you can ask in terms of would a child lie, I think that goes to your theory of the case, but would you be okay if we, trial counsel, would you be okay if we rephrased it as, do you believe that a child witness would necessarily be more or less credible than other witnesses? And said, well, I'll let you ask that question, but not the way you originally framed it. Do you agree that it wouldn't have been an abuse of discretion for the court to ask that the question be changed in that manner?
Yes, Your Honor. I mean, just to make sure that my answer is clear, I don't think that this question was improper in its framing, but I think the court could have very fairly suggested a different question or something that it was more comfortable with, and so long as it went to that general bias, I mean, that's where the abuse of discretion happened, was that Mr. Wall wasn't allowed to inquire into this very significant potential bias of the panel.
And I guess my last follow-up on this would be that last point that you made about the defense counsel wasn't allowed to inquire in another way. Defense counsel never suggested a rephrasing, and trying to say, well, what if we didn't ask it in those terms? What if we asked it this way? And it seems to me that we can't put the burden on the trial court to say, I'm not going to let you ask it this way, but here, let me give you some options of how you could ask it. But that's not really the role of the trial court to figure out the counsel's next step, but that is counsel's next step. How do we, I'm not sure that I agree that by saying you can't ask that question, that was a clear indication to counsel that the door is closed on the topic of bias.
It's possible, Your Honor, that we might just disagree then. I think the first question and the way the other questions were handled in that discussion with the court suggested that the court, it shows what the court was like with counsel when he was engaging with counsel about those questions. And I think it's difficult to really know what the tenor of the court was, just from the transcript pages. And so I think those other questions should be given a great deal of consideration, that when the court was willing to engage in changing the form of the question to allow the question, that was made clear to counsel, and they did do that. And so the fact that it didn't happen in this case shouldn't be seen as a failure of counsel, but instead as evidence of how the court presented that question. It was an emphatic, I will not allow that question. I will not allow you to inquire into or to expose the jury to your theory of the case. We're moving on. And I think that kind of emphasis would show that counsel really, it would have been a futile objection, and that under Roethlisberger isn't required.
Thank you.
Thank you, Your Honor. So moving on, I guess, to the second question in Lilley. The second question really isn't a question, and that was the issue. Instead, it asked the jurors to think about what they would do if they were the only juror who wanted to say that the defendant was guilty or not guilty, and if they would change their mind. And as the court pointed out, that doesn't look a bias, that is just a statement, and instead kind of sets the jury up to believe that it's them against their other jurors. So that's obviously different than our question, where it's not a question at all. And the last question is also, I think, important to this case, to distinguish for this case. The defense counsel wanted to ask, you will later be instructed by the judge that the identification of a person as the perpetrator of a crime is an expression of belief or impression by the witness, and that many factors affect the accuracy of the identification. Do any of you believe that an eyewitness can never make a mistake? Would any of you be unwilling to follow the judge's instruction about looking at the various factors which could affect the accuracy of eyewitness identification? And this court concluded that that was priming the jury to the defense's theory of the case. And so I think it's useful to break down here what exactly was happening. That the main question is the one sandwiched in the middle of those three sentences. Do any of you believe that an eyewitness can never make a mistake? And so there is an important distinction from that question with our question. First of all, it's the emphasis of never, and I think that kind of absolutism in the question suggests something to the jury that is maybe improper, and that does not exist in Mr. Wall's case. It was just a general, do you believe that children are capable of lying about significant events? And then secondarily...
I do want to interrupt you since you're getting low on time, because I do have a question about your second point that you've raised, which is the objection in closing to the prosecutor's statement that I believe I have no reason to misconstrue details. And this is the statement that was objected to by defense counsel and was overruled by the trial court. And I've been trying to figure out what, I mean, you've made the argument that this was bolstering the witness's testimony. And I'm trying to figure out what testimony was this statement bolstering. So the state points out that the defense counsel had impugned the prosecutor and the prosecution, not so much the witnesses, and that's why this statement was made in response. And your argument is that it was not properly response to being impugned by the defense attorney, but rather to bolstering the witness. And I'm trying to figure out, what testimony do you think it was bolstering? What details that the prosecutor said she wasn't misconstruing do you think were being bolstered? I've had a hard time connecting those dots, so I'm hoping you can do that for me.
Yes, Your Honor. I think that it's just Child's testimony generally is unreliable, and she told 4 different stories at different times. That her first CJC interview is different than what she allegedly told her father on the way to the lake. She only alleges any sort of abuse in the SANE exam after being prompted by the examiner, and then during the second CJC interview, she does make a disclosure only after telling the investigator that she had been told by her father what to say. And so then when she gets on the stand and gives her story, those details matter, and the differences between those stories matter. And so those are the details I think that the prosecutor was perhaps saying she had no reason to misconstrue, that the differences about whether her bad spot was her bum or her vagina, or where Wayne's bad spot was. All right, all of those, there are just these small details that don't add up in the story. And so when the prosecutor says, this happened, the child was telling the truth, Mr. Wall is guilty of, right, these charges, she's asserting that the very clearest version of child's story is the truth.
You also suggest that by that question, the prosecutor was indicating that the prosecutor had was a neutral entity and not one taking a side. The state responds to that notion simply in a footnote and says, number one, that argument wasn't preserved. And number two, even advocates who do take a side don't have an incentive to misconstrue evidence. That's not what advocates do. I'd be curious to your specific response on both of those. Is this argument preserved? And is it an argument or is it an issue as far as preservation goes? And then the second question, just how does that show that the advocate is being something other than an advocate?
Yes, Your Honor. Sorry, I'm just going to flip to exactly what defense counsel says that the prosecution claims is the fair reply. And I think that it might color this discussion. It says, it's the job of the government with all of their resources and all of their professionals, all of their people, CJC team, to seek justice for everyone, but somewhere, somehow, that changed into seeking convictions. And then she goes on to talk about how it's
Can you
hard to
remind me
challenge
what
the system.
page that is?
Yes, Your Honor, it's 846 and 47.
Thank you.
And so with that coloring, I think it would be hard to say that that wasn't the exact point of this argument, that the defense counsel was trying to remind the jury that the prosecutor is in fact seeking convictions, that the prosecutor was there today not just to tell a story or to say, well, we don't know, you decide. The prosecutor has chosen a side. So it absolutely was preserved. I mean, that was the whole point of the argument. And secondly, I think that is just one issue in the argument, right? I mean, so I always get confused about which word goes with.
Let me rephrase the one part of the question then. It seems like you can say, yes, I'm an advocate, but my job as an advocate is not to misconstrue the evidence. It's to make the best argument I can for my side within the evidence. And therefore, for the prosecutor to respond by saying, I have no incentive to misrepresent the evidence, isn't necessarily the prosecutor saying, I'm a neutral here. Does that make sense?
Yes, I see your point now, Your Honor. But I think in this context, it wasn't just, I have no reason to misconstrue the evidence. It's attempting to step back from the statement that she's seeking a conviction. And at the end of the day, that is what she's doing. So whether or not she has a reason to misconstrue the evidence, right, that's fine. But it maybe was also just improper for her to suggest that she, right, it goes into also suggesting she knows more about the evidence than the jury, that it goes beyond just saying that she's a prosecutor and she's not here to try to trip anyone up, and instead is suggesting, she says, child is telling the truth, the family is telling the truth, and I have no reason to misconstrue those details.
Thanks.
Further questions?
Can I
Yeah.
ask one more question about the prejudice on the first question, or I guess the child is lying question? And you don't have to show actual bias, but, I mean, the state is kind of saying that you do, but what is the harm that you have to demonstrate? Don't you have to demonstrate that the conviction would not have occurred?
Your Honor, I think under Depew and Holm, it's really the substantial impairment of the right to intelligently using your peremptories and asking for a for-cause strike. So Depew perhaps phrases the harm a little bit differently, but I think that ultimately fits into that substantial impairment standard that, all right, DePuy says that it's likely someone would have been struck for cause, but if your ability to intelligently conduct voir dire is hampered, then it is likely that you've missed someone who should have been struck for cause. So really, I would say that DePuy and Holm are proposing the same standard, and as you know from our briefing, we disagree with the state that it should be the same standard as an actually biased juror, because we can never get there if
The questions
voir
are being
dire.
asked. Okay, thank you.
All right, any further questions? Okay, thank you. We were keeping you past time, so you will have your full rebuttal.
Thank
We
you,
will
Your
now hear from the state. Mr. Haynes.
Thank you. May it please the court, William Haynes for the state. The state will rest on its briefing on the question of whether the voir dire limitations are even properly before the court, unless the court has questions about preservation. Otherwise, I'll focus my time on what the analysis looks like as if this was preserved. And the first thing to remember is that the standard of review here is an abuse of discretion. So if there's two reasonable ways to view this question, and one of them would have been improper, then it would not have been an abuse of discretion for the courts to refuse the request to ask this question. And the case law is clear that there are questions, even if they could go to bias, if they are improper for any number of reasons, that they shouldn't be allowed. And some of those reasons are if they're suggestive of a particular defense, or if they are simply highlighting, previewing the defense for the jury, or trying to tease out which jurors will be receptive or not receptive to a defense.
And is the issue here really the use of the word lying? Because it seems to me, I think Judge Luthi posed this hypothetical alternative phrasing, that if it had addressed the credibility of that witness, giving it more weight or less weight, directed to children, it seems like that would have been permissible. And so really what we're dealing with here is the term lying, it seems.
Absolutely. That is what makes it suggestive and makes it kind of previewing the defense that this child is lying. I agree that it was asked broadly about children generally, not about the specific child, but it's the suggestion that children lie is what is problematic about this.
And what do you, or how do you respond to the argument that was made here in argument that the sort of nature of the questioning and the back and forth of the questions before that made it such that defense counsel understood that this topic itself was one that could not be pursued, as opposed to the wording of the question?
I think the fact that the court explained its reasoning refutes that assertion. The court didn't say, we're not going down that road. It didn't rule in such a way that it made it clear counsel shouldn't even ask for another way to get at the issue or suggest or to explain what they're asking for. The court said, I'm not going to let you argue that any particular witness is lying. You can make your arguments, during trial, but I'm not going to let you argue your defense in voir dire. And so if what counsel was really getting at was bias, instead of wanting to suggest to the jury that, the child is lying, then counsel had every opportunity to say, I'm sorry, Your Honor, but that's not what I'm trying to suggest. What I'm trying to get at is bias toward a victim. Counsel would have known that from the voir dire questionnaire that went out, that the court would have been open to a neutral phrasing like they asked about law enforcement officers. Would you give a law enforcement officer more or less weight than any other witness? Counsel could have asked that question. Counsel could have, there's any number of ways counsel could have rephrased this, and the court, nothing in the court's ruling foreclosed counsel from doing that, or from even asking the question during voir dire. There are many opportunities where the court said, all right, any parties have any other questions? The only thing that was off the table was asking, do you believe that children are capable of lying? Counsel would not have run afoul of that order if he'd said, do you believe, or had said, you need to judge the credibility of a child like any other witness. Can you do that? Counsel also could have a month before trial, the state had proposed a jury instruction about child witnesses on page 367 of the record. It was ultimately given to the jury on 468 of the record. Counsel could have used that instruction and said, you're going to be told that that no witness is disqualified because of age. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true. Can you follow that instruction? There's many different ways the counsel could have asked this question, gotten at the issue of bias, but asking if you believe children are capable of lying is not one of them. So it was certainly within the discretion of the court to believe that this phrasing, this form of the question was improper, and the court said exactly what it was concerned about. And I think that is very much like the example of, do you believe an eyewitness can never make a mistake? That suggestion of never making a mistake, I agree that was the problem there is, that absolute, they're making mistakes, they can never make mistakes. You could have asked that same question any number of ways, saying you're going to be given an instruction about the factors that affect the reliability of an eyewitness's testimony. Can you follow that? Can you judge the credibility of an eyewitness like you would any other witness? There were many different ways the counsel could have gotten information that could have revealed bias. And so it was reasonable for the court to say, I'm not going to allow you to ask the question that you've suggested. On the question of prejudice, while it does have to show actual juror bias, this court in Depew suggested there was a difference between for-cause challenges and limits on voir dire, but King was a case that involved limits on voir dire. There was an allegation that the trial court should have allowed follow-up questions. That was invited error, so the court didn't reach it. There was an allegation that counsel should have asked more follow-up questions, but that idea of limiting voir dire, not asking questions that could have led to more information. In King, the court said, you need a showing of actual juror bias. And it said, even though that was ineffective assistance, it said it's important to have the same prejudice standard for ineffective assistance and for preserved claims. Wall tries to categorize these, draw a different line between different types of challenges here, saying there are challenges to any challenge to bias or any limit on voir dire are two different categories and we need different prejudice tests. But I think it's important to think about what that leads to. That creates a situation where you would have a harder prejudice showing when you have a showing of potential bias that needed to be followed up on, and then an easier prejudice showing when you have no indication of any potential bias. The question was just never asked in the first place. And so I think that simply can't be the rule, especially if you're using the substantial impairment test, which really acts more like a structural error test. If there's a substantial impairment on the defendant's right to ask questions and get information, there's, at least the way that's been applied, is essentially, any limit is reversible error. And it's important to remember that the purpose of voir dire is to ensure an impartial jury. If the defendants certainly have a right to ask questions, a right to seek information to allow them to exercise for-cause and peremptory challenges, but the purpose of peremptory challenges, and the Worthen makes this clear, is to allow attorneys to ensure an impartial jury, to make objections when they can't make a for-cause challenge, but based on instinct, hunches, based on impressions they have that they think there is a juror who could be biased. They can't make the for-cause challenge, but they want to ensure the right to an impartial jury. So frankly, I don't think it makes sense to treat the right to ask questions, as a more important right than the right to an impartial jury. So a showing of an actual biased juror sitting is a requirement that the Supreme Court has put in place, and I think this court should recognize that. And there is a mechanism. Wall suggested that's impossible to make that showing, but
I was going to ask, practically speaking, how would you make that showing?
so it could be done in a case like this where the state's position is it was not preserved. You could make a 23B claim if you had the evidence, a new trial motion as well. Counsel is able to talk to jurors. They don't have to talk, but it's just like any claim that you make in litigation. You investigate, you get the information, you talk. Jurors often talk, even if they don't talk to counsel. They might post on social media. They might talk to friends about their mindset, their bias. And if you can get that information, there are mechanisms to put it before the court.
Seems like from a practical matter, what you're saying is that anytime a party has concerns about how voir dire went, then they better be outside the jury room or outside the courthouse, trying to snag jurors on their way out, and then following up in a pretty determined manner with jurors. And I'm not sure that, well, just a practical matter, that seems a pretty high burden. And is that the message we want to send to jurors, that the court system is incentivizing dogged follow-up with whether they were biased?
Well, it's incentivizing, appellants of carrying their burden. Defendants who truly believe that there were improper limits on voir dire, they need to do the work to create a record to show that there was an improper limit, but also that they were prejudiced in some way. It's like any other claim that we have. And the court has already recognized, the Supreme Court has recognized that doing post-trial voir dire through a new trial motion or through 23B is proper. And so the Supreme Court has already sent that message that these are mechanisms, they're avenues that are available to counsel. And I don't think it should be pursued, as simply a fishing expedition to see, like, are there problems? Maybe we can, create an issue. But if counsel believes that there were limits on voir dire, that, and they need to make a case that it actually prejudiced them, then they need to do the work that any litigant needs to do to make a claim.
The premise of this question may be mistaken, and you can tell me if it is, but Holm came after King, which I think followed the Depew notion of substantial impairment. I think that Alvarez and Taylor may also have followed that. It seems like we've got a line of cases subsequent to King. Are you asking that we overturn a line of our precedent? What's the term that you would be asking us to do? Because if that's the question, I don't know that it's been briefed in the traditional way of when we overrule our own precedent.
We're asking the court to disavow those cases. They're inconsistent with King. King is the controlling authority here. There are two inconsistent tests here, and the court has to decide which one to apply, and it should apply the controlling test from the Supreme Court, and simply recognizing that I don't think it's necessarily overruling, but even if it is overruling, the state hasn't gone through the Eldridge analysis because King has clearly spoken, and these later cases haven't addressed King and tried to distinguish King, and so they're simply out of line with King. I think just recognizing that disavowing those cases, I think, is the proper approach for the court, and recognizing that King governs is the way to go. And I understand, obviously the court is, understandably hesitant to do that, but I think, finding there's no abuse of discretion or that it's not even properly before this court, I think are simply the, perhaps easier, clearer ways to resolve this case. But we do believe that is the proper prejudice test that should be applied and should be acknowledged. I'd like to turn to the issue of the closing argument. With the fair reply doctrine, I think it's important to recognize that there are two variants of it. In Utah, the version we see most often is looking at whether the question is proper, and the fair reply doctrine suggests you look at the entire context in which the statement was made. And you look at, even though a fair reply doctrine doesn't excuse something that's clearly improper, the context will make it so that the jury isn't likely to view it as an improper comment. They're going to view it for what it was. They're going to view it as simply the prosecutor defending their integrity, and they're not going to take it as an invitation to decide the case based on information outside the record, or to trust the government, because they are the government. But I think that the stronger version of the fair reply doctrine is in the prejudice analysis, that even if it's clearly improper, even in context, that it's it's harmless, again, because the jury understands the context in which it's made. It does not undermine the fairness of the trial when the prosecutor's integrity is repeatedly impugned and they respond by vouching for themselves, not for the evidence. They're vouching for themselves in this case. And I think the statement that I have no reason to misconstrue details, that was a direct response to statements on page 269 of the record. This portion of the transcript is in two different places in the record, so I think we're citing two different page numbers, but it's the same argument we're citing to page 269.
Can you say what page number of the transcript that is?
Yeah,
Because I do
that's-
have the different part of the record in front of me.
That is 269 is the, 2269, excuse me. So that is the transcript, 2269. It's also in the 800 range as well. But the defense counsel argued the prosecutor met with Lily before trial and helped her, quote, come up with an explanation for what wasn't there. And then the prosecutor then came in and cleaned up Lily's trial testimony. And so when the prosecutor on pages 2280 to 2282, before saying I have no reason to misconstrue details, the prosecutor walks through Lily's testimony, walks through the evidence at trial, and ends with saying, she has no reason to lie and I have no reason to misconstrue details. This is a clear response to this idea that somehow the prosecutor is meddling with her testimony or trying to take her testimony and twist it, that the prosecutor is simply vouching for herself here, not for the witnesses.
Under the one version of the fair reply doctrine, you noted it could be that the prosecutor's response is technically improper, but viewed in context, it would be harmless. I brought up the footnote in your brief that to suggest that the prosecutor was saying they are neutral is not what was being said. And I agree with the literal words there that by saying that even advocates aren't incentivized to misconstrue the record.
Right.
But again, in context, it does seem like that may be able to be read as, I'm just a neutral here, and don't have an incentive one way or the other. Why in context could that not be read that way and us be being steered more toward the harmless or harmless prosecutorial misconduct rather than the other version of?
That it's just proper.
Right.
I think in context, again, it's the prosecutor is, any suggestion of neutrality, I don't think it comes from that statement, but the prosecutor does say at some point, we're just doing our jobs and following up on allegations. This was in a part that was not objected to. I think that's a clear response to the suggestion that the prosecutor, that their job changed from seeking justice to seeking convictions. So the idea that the prosecutor is not seeking justice, I think the jury would view that as a fair response to that suggestion that their job is just to get a conviction without regard to what is just. I think the prosecutor can fairly say, like, we're presenting the evidence to you. I don't have any incentive to misconstrue this. My job is to present a case to you. Obviously, the jury's not going to be mistaken to think that the prosecutor doesn't think that Wall is guilty. And they understand when the prosecutor is saying, I'm just doing my job and presenting this evidence, I'm not misconstruing things, the prosecutor understands that, yeah, they believe Wall is guilty, but they respect the jury's role as the fact finder. Their job is to present the case. They believe Wall is guilty, but they're leaving it in the hands of the jury to decide whether he's guilty or not.
I understand the argument you're making, but I'm not sure, and it may be on my end. Are you steering us by saying this, and you're talking about now the unpreserved objection, that's the first version of the fair reply doctrine, that it wasn't improper, or it may have been improper but harmless?
Yeah, I think it was not improper. I think the court could go either way, but I think it was proper for the court, for the prosecutor, when they're being alleged of only caring about convictions and not about seeking justice, to respond by saying, I'm doing my job of presenting a case to you. I'm not misconstruing details. The prosecutor never says I'm a neutral here, and my opponent is not. There's no statement along those lines. So I think it was proper, but if the court has any concern, and particularly so I think both statements, the preserved one and, well, the statement that was objected to, I think, again, that was not the legal theory on which they objected below. But they do make this argument to kind of overall to the other statements as well. A reasonable attorney could have certainly viewed that and thought, it's close enough that if I object, I'm not going to succeed on that objection. I'm going to be overruled in front of the jury. It's not worth objecting to that. And if another reason that particular statement is harmless is that the jury was told explicitly that both lawyers are advocates. On page 452, the jury instruction tells them explicitly they're advocating their views of the case, and that if they say anything that conflicts with the evidence, they rely on the evidence. And they're repeatedly told 4 other times that it's their job to view the evidence and decide the case based on the evidence. 2 times they're told that what the lawyers say is not evidence. So the suggestion that this prejudiced the defendant, particularly in light of the fact that the jury would have understood what the prosecutor was doing here, is defending their own integrity. I think Wallace simply can't make that showing in light of the evidence and in light of the instructions and the overwhelming evidence of guilt as well. My time's up. If the court has questions about the evidence, I'd happy to address that, but I will rely on my briefing otherwise and ask the court to affirm.
Thank you. I don't see that we have any further questions, so. Ms. Lovett-Howell, you have 3 minutes for your rebuttal.
Thank you, Your Honor. I just want to make 2 points. First, Holman Depew are still binding case law. The state, as was pointed out, has never asked this court to overrule either of those cases. Holm was published approximately 10 years after King, and in fact refers to King in its decision to discuss a different point. And the fact that Holm was decided after King, I think, just further supports the suggestion that Holm and King are dealing with 2 entirely separate issues, that an actually biased juror sitting is different than a voir dire restriction and needs to be treated differently. And second, the harm of the prosecutorial misconduct in closing, I think, is highlighted by the fact that counsel objected. So using red cap as a counterpoint, just like we suggested in our briefing, the fact that trial counsel went to the effort of making an objection to that statement, especially when it was unclear whether the court would agree with her or not, really highlights the fact that this was damaging testimony, and in the context, it needed to be damaging. I, again, would just point to the fact that it's difficult to know the importance of a statement just from the transcript, and instead without the tenor of the courtroom. So unless there are questions, I think those were my 2 points, and we would rest on our briefing.
All right, I don't see any further questions, so thank you to you both for your excellent briefing in this matter and your arguments today. We will take this matter under advisement and issue a decision as soon as we are able to do so. And we will excuse Ms. Lovett-Howell and Mr. Haynes from the courtroom, and we'll remain on the bench for our 10:15 hearing. So thank you so much.